Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning and welcome to the October docket of the Court of Criminal Appeals, the Eastern Section. First of all, let me thank Nick Morgan and Francesca Kraft for their help in orchestrating all of this. All we have to do as judges is sort of sit and let it happen. So we appreciate that. On the panel today is Judge Camille McMullen from Memphis, Judge Jill Barty Ayers from Clarksville, and I'm Kelly Thomas from Maryville. I presume we have no preliminary matters, do we, Madam Clerk?
No, sir.
Okay. Then you will, as usual, have 20 minutes per side. If the appellant wishes to reserve some rebuttal time, please let me know that when you start your argument, and I will I'll give you a little heads up when you get within a couple of minutes of the end of your initial argument. So, if you will, call the case.
State of Tennessee versus Emily Leanne Brooks.
Okay, Mr. Davis.
Good morning, Your Honor. Judge Thomas, I'd like to reserve 2 minutes for rebuttal.
2 minutes? All
yes,
right.
Please. Your Honor, this case involves a fairly simple question. It's whether or not Emily Brooks has raised a fair and just reason to withdraw her guilty plea. This is a case where a 28-year-old young woman entered a guilty plea open to second-degree murder on a one-day take it or leave it offer, open offer, and felt pressure and entered the plea.
Let me ask you one question about that, if I could, Mr.
Sure.
Davis. Is there any question about whether or not the state's plea offer was plea today or it's off the table? Does everybody agree that that's what happened or not?
Yeah, there's no dispute in that. There's nothing in the record to suggest a dispute to that.
Okay.
I think the corollary to me being candid with the court would be she had been presented with 20-year offers in the past. So it's not like she'd never been made an offer before. And this is the first time she's made an offer. So in all candor to the court, this is a case that had been going on for some period of time. There'd been a motion to suppress evidence. There had been a previous 20-year offer rejected. She'd never entertained it. What's significant to me is that she came to court to pick a trial date. So you have a 28-year-old young woman who's never been to criminal court before. She had 9 other cases, many of them clumped together, all of them in sessions court. She never served any serious time before. Here she is. She's given this take it or leave it plea to second-degree murder. Her parents.
Counsel, isn't that what's inherent in a take it or leave it plea? You are inherent within a take it or leave it plea, given a one-day opportunity to consider the state's offer. Yeah, it's inherent in a plea negotiation, is that not?
Yes, and I think a plea, and I'm a former prosecutor, I think a one-day take it or leave it plea is unethical on its face. I think a prosecutor who's been involved in litigation with the defense attorney and knows that her parents are sitting there in the courtroom, she doesn't have any access to them, and to make an offer of a one-day take it or leave it plea, I think that that's on its face a major problem. I also think it's a problem.
Would it make a difference if it was, let's say, a case that didn't have a lengthy procedural history, whether a one-day offer would make a difference? Would the circumstances make a difference in your mind, whether a one-day take it or leave it offer was unethical in its space? Speak to that for me, counsel.
I don't think it's the procedural history so much as the seriousness of the case. If somebody said one-day take it or leave it plea on 11/29 suspended, it doesn't seem to me to raise my concerns. I think when you're dealing with a first degree murder charge and a second-degree murder offer, I think the seriousness of these things, especially given that there's been a history in the case, you give the person an opportunity to consider it. Look what happened here.
The alternative is no offer at all.
Well, I don't think this really was an offer. I think to threaten somebody with a first-degree murder trial and then an offer of second-degree murder.
You're using strong words, counsel, when you say threaten. The charge was what it was. It was a first-degree murder charge on its face that you all had been litigating for over 2 years, is what I saw in the record.
I hadn't been litigating it for 5 minutes. I got called the day.
Well,
I got
I'm not
called
speaking
within
to
an
you
hour.
personally. I'm speaking in terms of what the record shows in terms of
Well,
what defense counsel had been litigating.
But that's why my concerns are so strong, is that when this family contacted me and told me about what happened in this case and a take it or leave it plea, I know the attorneys involved in this case. And for a public defender to put somebody in a take it or leave it plea situation on one
Well,
day,
the public
to
defender
me,
was obligated to communicate that offer to the client.
certainly, and the defense attorney is also obligated to tell the prosecutor this is ridiculous to make it take it or leave it. And the point I'm trying to make is her parents were sitting right there in the courtroom. Part of the problem the state has is the conversation that she had with her mother the next day. If they allowed her to have a conversation in the courtroom that day and the plea went forward, we could say with certainty that she knew what she was doing. Here, the problem I have is a couple levels. One, it's the fact that she was prevented from discussing this with her parents who were right there, and she expressed that she wanted to. And then two, she has a significant brain injury from.
Well, I mean, there was a forensic evaluation at the very beginning of the case. And that showed that she didn't have any serious mental deficiencies. Also, the court explored that during the plea colloquy. I don't think you get much mileage out of the mental deficiency that she submitted in the post-plea procedure.
Well, I disagree with you. I think it's an important factor. Neither the court nor the defense attorney were aware of the fact that she had a closed head brain trauma injury. What you're talking about is she was evaluated for competency to stand trial. Certainly, I'm not saying this plea was incompetent. I'm not saying that she was incompetent in the plea. At the time she entered this plea, she was competent to enter this plea, no doubt about it. And within hours, she was doing everything in her power to reverse what she had just done. And the question is it for a fair and just reason? And I think that a relatively young person like this, who expresses such concern so quickly and has the ability to hire a lawyer, and we have all the papers filed within 7 days, that's a pretty clear indication that she really wants to withdraw her guilty plea. It's not like she waited and gotten sentenced, or she waited till the day before the sentencing hearing. She realized as soon as she came out of that courtroom, a courtroom she went to pick a trial date, that she regretted what she had done. And she took every step to do that. I don't believe that the defense attorney had any knowledge about the closed head injury. I don't believe the judge did. I know both the judge and the defense attorney. Had they known about that.
She entered previous pleas to guilty charges after her head injury. Isn't that correct?
Right. Sure. And if you're familiar with Sessions Court, that's bus station justice. People go in there and things are entered.
That I read, it wasn't just Sessions pleas that she entered guilty pleas to.
No, they're all Sessions Court. There's no plea. Everything in her history, there are 9 separate charges. A number of these are lumped together. I think she was there maybe 4 different times for guilty pleas, but she had never entered a guilty plea except in Sessions Court. She'd never been to criminal court before. The first time she'd been to criminal court is on this case at 26 years old. She's been locked up for 2 years, and then this is the first guilty plea that she enters.
I've taken up a lot of your time, counsel. This trial judge did, from what I recall, he filed an extensive order both on your initial motion to withdraw as well as a second motion to reconsider. He did what I believe to be a very thorough job in addressing your issues. Can you speak to how the trial court considered, I guess, the standard of review here?
Sure.
And I guess the Phelps factors.
Right. I think that where the court made a mistake is on the Phelps factor number 2, why grounds for the withdrawal were not presented earlier. And he felt that was neutral. And that's just flat out wrong. If you look at number 1, the length of time between the entry of the filing of the plea and the motion to withdraw, in this case, there was no length of time. She immediately sought to withdraw it. So that implicates number two, why the grounds were not presented earlier. If we follow Judge Poole's reasoning, this factor can only be used to hurt you if you wait and do it later in the process. He found it was neutral because she did it so immediate in the process. And what I'm saying is that's an incorrect evaluation of it. If you can use this to harm somebody later in the process, this should be significant weight because she's doing it so quickly in the process. This magnifies factor one, the length of time between the entry of the plea and the motion to withdraw. The fact that it could not have been presented any earlier shows how strong factor one is and shows how strong her interest in reversing this is. I've looked at the cases cited by the state. I've looked at a lot of the cases where motions to withdraw are denied. And those cases often are where the person waits till after sentencing, or they wait till the eve of sentencing. There's a period of weeks or months of reflection. Here, because it was so immediate, it's on factors 1 and 10, or 1 and 2 are extremely strong. Another thing that Judge Poole, I think, got wrong was this conversation with her mother. He attributed the greatest weight to that this was somehow a strategy to file a motion to withdraw, and then in that, maybe you get a better deal. Those were words spoken by her mother. And if we're going to evaluate the motion for the guilty plea, I don't think she should be harmed by what her mother is telling her on a tape recorded phone call from the jail. That to me also underscores why it was so important that she be given allowed to speak to her mother and her father, who are both in the courtroom. Her mother and her father, this is the record, are not married. They're divorced. Each of them were there independently. Each of them asked the defense attorney to speak to her because the case was being set for trial that day. She asked her defense attorney to speak to her parents, and she was prevented from doing so. How she is harmed is there's a tape recording of her mother saying,
speak to this for me, and then I'll let you,
sure,
continue. This is not like a juvenile, who needs to speak to their parents before they enter a plea. This individual is a 28-year-old adult. So you make much of the fact that she was not given the opportunity to speak with her parents. And I'm not sure that I don't know why that's being made to be so significant in this case.
Well, when you get to be my age, maybe 20 years is not that big a chunk of time. When you're 28 years old, we're talking about a plea that's literally probably potentially beyond what she can remember in her life experience. So an open plea that could carry 20, 25 years of prison time, you're 28 years old. I don't think that she is a juvenile, but I think a 28-year-old who has such a weighty decision to make in life and has divorced parents who've each taken time out of their day to be there.
You're saying on a lot of factors that, ordinary people going into a courtroom don't get these things. In terms of being able to consult with their parents, I just think you're putting a lot of weight onto that the trial judge, didn't have to do that.
Well, he didn't do it for sure, but I've never heard of a case where someone was entering a plea to second-degree murder and they expressed interest in talking to their parents, or vice versa, where their parents have expressed interest in talking to them. As a prosecutor, I've never seen it where you prevented a defendant talking to a family member if they're going to enter a plea, especially if to prevent these situations. You're there to pick a trial date, right? Everybody wants the same thing at the end, right? You want a knowing and voluntary plea if it's going to be a plea. If you're there to pick a trial date and you're not picking a trial date, you're there to pick a trial date, and now you're going to instead have a guilty plea. Why wouldn't you want her to speak to her parents? The state should want her to speak to her parents, make sure everybody's on the same page.
That to me is, I guess, incorporated into the trial court's plea colloquy. When the trial court goes through the questioning of the defendant. So, now that you're second guessing that with whether it was knowingly and voluntarily entered, it's hard for me to say that the trial court didn't allow her the opportunity to explore more. She entered this plea agreement as you've already admitted, of her own volition, saying that she hadn't been coerced into doing so. So, I'll let you conclude.
No, that's absolutely true. What I'm saying is there are fair and just reasons under Phelps to allow
I
her to
understand.
withdraw.
I understand. I understand.
And I'm saying that you look at these things together. It's just this is the type of case where what harm is there to the state to allow her to have a trial if that's what she wants? There's none, right? There's none. And so why are we preventing her from having a trial if that's what she wants? She so clearly expressed her interest so quickly. I'm no miraculous attorney. If I can get this thing filed with affidavits and everything in front of the court within a matter of days, clearly she wanted this to happen. I just think it's the case of an overworked attorney who cut some corners, not intentionally, but just cut some corners, entered a plea, didn't want her to talk to her parents, take it or leave it one day, when really what we should do in these cases, attorneys need to stand up and say, well, we're not going to bow to a one-day plea offer. That's ridiculous. No, and it's hollow. There's no prosecutor that's going to make an offer of a one-day plea offer and not give it to you.
I beg to differ. That's in their toolbox, and we shouldn't be judging what they use in their toolbox to effectively move their cases.
Well, that is a bad tool. That's one that should not be used. It's not good for anybody. Look what it does in a case like this. Imagine if they had just given her overnight to think about it and she entered a plea. We wouldn't be here. The fact that it's this kind of pressured situation and given her facts is why we're here today. You have questioned the seriousness of her closed head injury. I think to me, that's a real problem. You got a closed head injury from somebody and the judge doesn't know it and the attorney doesn't know it. How do you factor that in? The affidavits of her parents say that it affects her ability to make decisions under pressure. And so here she was making the most monumental decision in her life under pressure. Again, I'm not saying she's not competent.
Did your medical records provide that? Because from what I understood in the record, the medical records didn't make the connection that you suggest, that it somehow had some sort of bearing on her ability to make a decision. I understand she had a serious head injury several years prior to this, but I'm not sure I saw where the medical records bear out what you're suggesting.
The medical records document the nature of her closed head injury and the brain trauma, and that's undisputed and it's cited in the state's brief. Her parents, again, divorced, living independent lives, each in their own affidavits, talk about how that has affected her ability to make decisions. Again, she's competent, clearly, but it affects her ability to make a decision under pressure. I can't imagine a more pressured decision than a one-day take it or leave it offer to an open plea of second-degree murder, when the other option is set her for trial, and that's what she was there to do that day. So I think that factor is important.
You've got a couple of minutes, Mr. Davis, before you start encroaching on your rebuttal time.
Well, I'd like to hold my rebuttal time unless if there's any questions from the court, I'm happy to answer any other questions from the court.
No, I mean, you've got 2 more minutes before you encroach on your rebuttal time if there's some other things you want to bring up.
Well, I think the only other thing I'd like to bring up is this discussion about her insistence on her actual innocence. I think that in a case like this, when somebody enters a plea of not guilty, that's the way they speak and say that they're actually innocent. The fact that there's a procedural history here where she's trying to have the evidence suppressed supports her actual innocence. The fact that she has filed a motion to withdraw immediately supports her contention of actual innocence, because if it's successful,
but she never asserted her innocence. She never asserted her innocence.
No, she pled. She pled guilty. Is what she did on that day, and then she immediately beforehand was asking for a jury trial, and immediately after is asking for a jury trial. And what I'm saying is, while she didn't say the words in the guilty plea, "I'm actually innocent," of course not. At that time, she was under the pressure and made her decision to enter a guilty plea, which she did. Immediately afterwards, she sought to remove the guilty plea, and you only do that when you're asserting your actual innocence because she
I
wants to
don't,
go to trial.
I don't know if that, I don't know if I'll buy that, counsel. I think what well, first, let me back up. Is the recording between the mother and the defendant in the record?
It is. There's a transcript of it. Isn't it?
All right. And she didn't assert her innocence as a basis to withdraw the plea during that conversation.
They certainly don't use the word actual innocence in there, but
Or
she is
yeah.
insisting, she's insisting on going to trial. The daughter is, and a fair inference of that is that she's actually innocent. The mother is insisting on, well, maybe you can get a better plea offer. Look, the mother wasn't there, right? And so the mother doesn't know the facts, and the mother's fearful for her daughter. But her actions in asking for a jury trial and telling her mother on the call she wants a trial, that there's an inference there that's what she's asking for. And so I think the judge puts the most weight, Judge Poole puts the most weight on turning this factor down because of that phone call. And he was clearly upset by it. And I get it. You don't want people manipulating the system. What I'm saying is those words, when you go back and look at it, come from the mother. And I don't think that that's a reason to outweigh these other Phelps factors. And you look at these other Phelps factors, I mean, you've got somebody who's asking for a trial immediately. And I think the court made a mistake by not giving it to her. She had a fair and reasonable reason to do so.
Thank you, counsel.
Thank you.
Mr. Brandon?
Your honors, and may it please the court, Cody Brandon for the state of Tennessee. We respectfully request that this court affirm the judgment of the trial court. Trial court, in this case, properly exercised its discretion to deny defendant's motion to withdraw her guilty plea after balancing all of Phelps factors. Defendant did not have a unilateral right to withdraw her guilty plea, and this court reviews the trial court's decision for an abuse of discretion, looking at the balance of those factors. Just to address the factors one by one, the trial court correctly found that the first factor was the only factor that favored defendant. She did file her motion to withdraw a guilty plea within 1 week, and that short time span in between her guilty plea and the motion to withdraw was a favorable factor, but it was outweighed by the balance of the remainder of the factors. The second factor, the reason for the delay, was neutral in this case because the delay was so small. There was no explanation needed for that delay. Instead of double counting the first factor as defendant suggests should be done for short delays, this court should look at the first and second factors sort of in tandem, that when the first factor is short, it will favor allowing withdrawal of the guilty plea on that factor, and the second factor is likely to be neutral because there's no reason to explain a short delay. But in cases where the delay is long and might disfavor allowing a motion to withdraw a guilty plea, the second factor may balance out that first factor if there's an explanation for the long delay. So in this case,
So the second factor can never weigh in favor of the moving party. It's either neutral at best or against the person that wants to withdraw their guilty plea. Is that what I'm understanding you to say?
no, Your Honor, that's not the state's position. It can work in any direction.
How does it work in favor of the person that wants to withdraw their guilty plea then?
It certainly could, Your Honor. In the case that the first factor disfavors allowing withdrawal when there's a long delay, the second factor could be very helpful to a defendant in explaining that there was a long delay for some specific reason and rehabilitating that case for the motion to withdraw.
Okay, like the person was in the hospital, whatever. Okay, I got you.
Right. So those two sort of balance each other and work in tandem instead of working to double count in this case, where really the second factor is just neutral because there was no delay to explain. The third factor the trial court considered is whether defendant asserted her innocence, and she did not. Defendant claims now that filing a motion to withdraw a guilty plea is an assertion of innocence, but this court has both previously rejected that argument, and to accept it now would be essentially to neutralize this factor, because every defendant that filed a motion to withdraw a guilty plea would be able to claim that he or she asserted her innocence in that motions. In this case, the trial court correctly found that defendant had not maintained her innocence. The fourth factor is whether the circumstances underlying the guilty plea. Defendant had previously lost a motion to suppress. She'd been in custody for 2.5 years and repeatedly refused 20-year plea deals before she was presented with this open sentencing deal. She reviewed and signed a detailed petition explaining what rights she was waiving and the consequences of her guilty plea. She indicated to the trial court that she discussed the rights and the petition with her attorneys, and she underwent extensive questioning by the trial court. That is all on the record. The trial court ensured that she understood the consequences of her plea and the rights that she was waiving. The trial court correctly found that that factor weighed against allowing the withdrawal of the guilty plea. The fifth factor, defendant's nature and background. The trial court found that defendant was very intelligent and very street smart. She was 28 years old, not a juvenile. The trial court found that the claims of brain injury were not credible. Defendant had previously been psychiatrically evaluated and determined competent to stand trial, and the trial court found that the record of previous brain injury did not affect her ability to make a decision on the guilty plea in this case, especially with the assistance of counsel and the extensive questioning of the trial court before the plea was entered. The sixth factor and final factor in this case, defendant's prior experience with the criminal justice system. Defendant had previously pleaded guilty to 9 other offenses. He was familiar with the process of pleading guilty and the rights that would weigh, the consequences of it. Those previous guilty pleas, again, help establish her understanding the process. So balancing those 6 factors, the trial court could correctly determine within its reasonable discretion that defendant was not entitled to withdraw her guilty plea. On top of the Phelps factors, which are not exclusive, the trial court also found that defendant was not credible when she testified after filing her motion that she could not remember the plea hearing or signing the plea agreement. The trial court explicitly found that testimony not credible. And of course, as already mentioned, the trial court found that defendant's intent in filing the motion to withdraw a guilty plea was not a simple change of heart or a fair and just reason for withdrawing a guilty plea. It was to gain a tactical advantage over the prosecution and specifically over the victims and witnesses in this case. Defendant discussed on the phone with her mother the fact that the victims were emotionally unwilling to go forward to trial and that rejecting this guilty plea would gain an advantage over the prosecution, that they could leverage those emotions against the prosecution to get a better deal.
Is that realistic? I mean, I know I questioned defense counsel greatly, but with a difference of a week, is that realistic that there's any real prejudice or advantage to be gained by the defendant in this case?
I'm not sure what advantage would have been gained by rejecting the guilty plea. The important thing is that the trial court found that in addition to all those factors, defendant's intent here was to attempt to gain a tactical advantage and wasn't an innocent change of heart, wasn't a fair and just reason for withdrawing the guilty plea.
Well, there has to be support for what the trial court did. I mean, that's what I'm asking you, counsel. With a week, I mean, it seems to go, in error to the defendant's benefit. I'm trying as a practical matter to understand what difference it would have made to the state in this case. They were already ready to set it for trial. I guess I'm trying to understand. Help me to understand how the trial court got there.
Yes, Your Honor, and I think you might be alluding to the 7th factor under Phelps,
Okay.
whether there's prejudice to the state, and that factor can come into play in some cases when the balance of the other factors is close. That 7th Phelps factor as to whether allowing the defendant to withdraw the guilty plea prejudices the state can tip the balance one way or the other. But in a case like this, where all of the other factors weigh heavily against allowing withdrawal of the guilty plea, the trial court didn't need to reach that factor. So for those reasons, because again, the trial court found the overwhelming balance of factors under Phelps in addition to defendant's lack of credibility and her attempt to gain a tactical advantage, favored disallowing her to withdraw her guilty plea. The trial court didn't abuse its discretion in this case. We'd ask that this court affirm the judgment of the trial court.
Thank you.
Mr. Davis, you have 2 or 3 minutes for rebuttal.
Thank you, Judge Thomas. Yeah, I want to go back to these Phelps factors, because this is a problem, I think. Let's start with what the state just said. We don't need to reach Phelps factor number 7 because it's not a close call. So if that's true, and I know these are non-exhaustive factors, but non-exclusive factors. So, but the state wants to say, well, we don't have to use number 7 because it wasn't a close call because it was so weighty. And then they say, well, now number 1 and 2, they can go in tandem, where number 2, since there was such short grounds, we don't give it any weight, it's just neutral, because the time between the entry of the plea and the motion was so short. So what they're doing is they're collapsing these factors, and it's always, it's like being in Vegas on these factors. The house always wins. Under your scenario that you asked, is like you said to the state, when could the factor number 2 help the defendant? Well, like the dealer in control of the cards, it can only help the defendant according to the state scenario when number 1 hurts the defendant. So there's no scenario the state can tell you where factor number 1 helps the defendant and factor number 2 is available to help the defendant. They're collapsing the two, saying you can only, and then if you ask for them to be to help the defendant, both of them, they want to call it double counting. That is not double counting. What it does is it indicates or supports or magnifies how important it is on a motion to withdraw that a defendant does it immediately, as opposed to after sentencing, as a number of the cases, or on the eve of sentencing 3 months later. So I think when you look at that, when you look at the analysis of Judge Poole, and again, I respect Judge Poole, I know Judge Poole well. I think what Judge Poole has done in this case is he's collapsed 1 and 2, doesn't reach 7 because I say he doesn't need to, and then we're left with a couple of here in the middle, and the one that gets him upset is whether or not she asserts actual innocence because of the comments made by her mother. And the comments made by her mother upset him because she is seeking a tactical advantage. And Your Honor, you know, Judge Thomas, as a former trial court judge, there's no tactical advantage in withdrawing an offer for second-degree murder and going to trial for first-degree murder. You know, more often than not, you'll probably regret that decision as a defendant as you're sitting there at counsel table with a first-degree murder trial, as opposed to a second-degree murder conviction. It's the unusual case where a defendant meets with new counsel, our office, goes through, and this is on the record, is carefully advised of the peril she's facing if her motion is granted, meaning she'll get a jury trial for first-degree murder, and she insists on filing it and gets it all filed within days of entering her initial guilty plea. So I think that when we look at properly at these factors, she has established great weight under 1 and 2 that was minimized by the court. The court overweighed number 3 on this actual innocence and never got to number 7. And 7 should have been invoked in this case if it were a close call, and whether the prosecution would be prejudiced. And the prosecution will not be prejudiced in this case at all. There's nothing in the record to suggest that the prosecution would be. Sorry, I don't know what happened there for a second with black. That would be prejudiced. But I think when you go back to these factors and you look at them fairly, I think this is a case where the defendant has stated fair and just reasons for her trial that the court just improperly weighed. Thank you.
Thank you very much. Appreciate your arguments. Madam Clerk, if you will, I guess, send us out to recess.
This Honorable Court of Tennessee is now in recess.
Thank you.